The father's request looks simple on the surface, but it actually asks the court to change how decision-making power works inside an already established custody arrangement. A right of first refusal sounds cooperative, yet it creates a new layer of supervision over the other parent's parenting time.
What is your current parenting time schedule?
We have week on, week off.
Ms. Wixon, as to his request of essentially a first right of refusal for babysitting needs, what would you like to say?
So the thing is, my mom has every other weekend off, which falls on my weekends with the kids. And that is her, she gets to see them those 2 Saturdays a month. And she doesn't really get to see them during the week. This is what it has been previously. And she goes to the grocery store. She buys like $300 worth of groceries for the kids, is very excited to have them for the night. And so we've been kind of doing that often, but the thing now is, now that school is over, my parents are who I use as babysitters for the day so I can go work. So I just don't think that it's appropriate that I have to call Jake every single day and ask if he would like the kids first before I take them to my parents so I can go work.
All right, so you're not in agreement then with that request?
No. And the other thing is that his mother currently is living in his house. So it's like if he could leave the kids with her and go do whatever and not call me, and I would never know.
All right, so a right of first refusal is not a standard language in custody orders. Parties sometimes stipulate to that, but when parties share joint custody or any custody during the time a child resides with a parent, that parent shall decide all routine matters concerning the child, which includes any potential child care that is needed while a parent is working or has some other obligation. So it is not standard or required that there be a right of first refusal. Again, the parties can stipulate to that, but absent a stipulation, the court does not order that. So I do not believe there's proper cause or change of circumstances regarding the parenting time motion. So that motion would be denied. And then Ms. Wixon, you had a motion.
Yes.
And what are you looking to do?
So the other thing is, I requested to have his child support waived previously. And with that, I feel that I have been purchasing majority of the kids' clothing, and it's like not being reciprocated, I guess. Like this week, the kids are at his house, and my daughter has trashed just this week, 2 brand new t-shirts that I just bought her and brand new socks. And that's fine if he was also purchasing, extra clothes for them as well. But it's like I keep buying them new stuff and they're coming back here in trash stuff. So I just want to figure out something to make it fair that we're both, putting in the same amount of money or, effort into our children's clothing and sports fees and stuff like that.
Well, parties are always able to come to their own agreements regarding the money that goes between the two of them. Either parent have the right to seek a child support order. Sounds like you previously agreed to deviate just to the medical, I believe.
Yeah.
So are you asking for a new child support recommendation, or are you asking for the chance to see if the two of you can agree to some type of
Yeah, I guess I just
arrangement?
wanted us to come to some kind of agreement.
Mr. Seibel, what do you want to say regarding the support issue?
I provide their clothes when they're at my house for the week. We actually stayed with Janelle this week, which is why when she woke up for school, she put on the clothes that we had at her mom's house, and they did happen to get dirty from school or whatever. But they do have clothes from my house as well as at their mother's.
He was at your house.
And I already.
Like I said, the court's not going to get into a fight over who's paying what for clothes. What the court can do is either order support or not order support. So I guess, Ms. Wixon, are you asking that the court order that a child support recommendation be prepared?
We'll just keep trying to work this out.
Okay. All right, then I will, given that information, then the motion regarding support would be dismissed.
Okay.
All right, thank you both for appearing. You're all set.
Thank you.
Calls the matter of Brianna Gillespie versus Devin Kukaba, file number 21-18663DS. Do we have the parties on that matter present?
Yes, good morning, Your Honor. I'm here.
Ms. Gillespie is present. We have Mr. Kukaba present. Does not appear that he is present. We have a couple different matters. We have a show cause regarding support, status hearing regarding custody and parenting time. So as to the show cause from the court, any update?
No, the defendant's support obligation is $189. This sum is composed of $139 for current support and $50 towards overdue. The defendant's payments were consistent through November of 2025, but since then, there has been no payments received. The arrears balance is $2,293.93. But there was hearings in regards to custody and parenting time since then.
Thank you. Ms. Gillespie, anything that you would like to say?
The mother's request for complete authority over the child's life reflects a misunderstanding many parents have after long periods of non-involvement from the other side. She sees abandonment and assumes parental rights should disappear with it. The judge draws a hard legal line.
Yes, Your Honor. I have tried to attempt to reach out to Devin. I've contacted his dad. His dad provided me with a phone number, which then I proceeded to let Shasta know the updated phone number. I've tried to reach out to him. He has not contacted me in regarding our child since December. And when we last had court, I still have not had any contact with him. He has not reached out to me. So at this time, I am asking the court for me to get full physical and sole legal, full everything for her, because I've been doing everything by myself since then, and he has not reached out to me, period.
All right. I think the last order did give you sole legal and sole physical. It did clarify it as a temporary order, but it did grant you those things. So you currently have that.
Is there any way that, since he hasn't reached out to me regarding our child, he hasn't showed any effort, is there any way that you would consider me just being the only parent to her, or is that what's in place right now, basically?
Really is what's in place right now, because you have the sole legal, sole physical. Parenting time is as the parties agree, meaning, you know, if he reached out to you for parenting time, you'd have to be in agreement for anything to happen. It'd be on him to file. It'd be on him to file anything that would change those terms.
I mean, I don't want him to have any rights to her, period. Is that something that I could do with him not being in her life or reaching out to her at all?
Me, I'm not a court that can terminate parental rights. That's a separate matter through a probate court or a neglect case. There are other methods, but yeah, that's not for me.
Okay.
Anything you want to say regarding the support matter, ma'am?
Yes, I haven't received any single child support payments, I believe, since November, December. And I would like to raise the child support because, like I said, I am raising her on my own. I'm not working right now. I'm being supported by my boyfriend right now. I'm a stay-at-home mom, and things are hard, and I need to know if I could raise the child support. I'm not going to look forward to even getting anything because he hasn't made a payment. But as I know, as far as I know, he's still in a mental hospital. supposedly, but then again, he's on social media posting that he's got new iPhones, he's got a new car. Yeah. So I would like to raise the child support if possible.
There might be an issue of whether or not, if he is in a mental hospital, whether or not it should be, whether he has the ability to earn at this time. We haven't done a new calculation or.
Your Honor, you did refer support after that temporary order to friend of the court for leave support review using 0 overnights, but in regards to collecting information, we have not had that, so would actually need the help through the court to input what his income should be, if anything.
And he does not respond or participate?
I have attempted to reach out to him at a contact number that an intake specialist provided from Harbor Hall with an anticipated release date of May 27th. That number that they provided, a voicemail box is not set up, and I've not had additional contact with Harbor Hall, even though I've left a message, but it was earlier this week.
I think we should get a rec prepared, and then that would give him a chance to potentially object if he thinks that we're not using appropriate income.
A prior recommendation was done based on a factory job that he had that then had stopped. So I'm unsure if it should be based on minimum wage.
I think we'd base it on his last employment then.
So whatever was inputted at the lab. Yep. During the last recommendation, but no overnights?
Yes. So Ms. Gillespie, we will prepare a new support recommendation with him at 0 overnights using his last known employment. It'll be a recommendation, so it'll give either one of you the right to object to the terms. Perhaps he'll participate and give the court some information as to what's going on, but it gives him that opportunity to do that if that's the case and he's unable to currently work. And it would be, as indicated, based on him not having any overnights, and it would go back in time a little bit to back when I had that last, when you guys had your hearing, okay?
All righty.
Your Honor, I do have one additional question. She had indicated that she is not working. Is there, as to like a reason, as like due to children's ages or anything like that, that could be potentially addressed right now? Sure. So man, we have to obviously address what your income would be at for the recommendation. So you're not working currently?
No, I have a 2-year-old son with another guy who is currently my boyfriend, and he supports us.
All right. So what was your last employment that you had?
It was over 3 years ago. It was a comfort care here in Gaylord.
Okay.
I believe the last recommendation, which was just prior to the March one, we inputted her for 35 hours at minimum wage. I don't know if that would be appropriate if she has a child that is not in school with the cost of childcare and things like that. We can do the recommendation and then if there's an objection, but that's what we would input her then.
Okay, yeah. Let's do that for hers and then she can object if she feels that's unfair and then also do him.
Is it okay?
But do him at 35 hours, make sure they're the same hours. Yes, ma'am?
Okay.
The other reason I'm not working is because my daughter has a mental disability, which is keeping me from getting a full-time job. She was diagnosed through the state of Michigan that she is severely autistic. That paperwork was provided to the court. She is going to counseling, on medication, seeing a psychiatrist. So it is very difficult for me to keep a full-time job at this time.
That recommendation, and if either one of you doesn't agree with the way it calculates out, then you'll have the automatic right to come in front of me and make those arguments, okay?
The final exchange introduces the strongest argument presented by the mother during the entire hearing. Unlike earlier complaints, this claim directly addresses her ability to maintain employment. Caring for a child with severe developmental needs can significantly affect work opportunities, scheduling flexibility, and income potential. The judge does not immediately alter the calculation because the court is focused on process rather than instant conclusions. That restraint is deliberate. family courts often separate the creation of a recommendation from the evaluation of exceptions. By allowing objections after the recommendation is issued, the judge ensures that supporting evidence can be properly reviewed instead of being decided in a brief hearing. The result is a balanced ending where neither side receives an immediate victory, but both retain a pathway to challenge the outcome.